All right, good morning, everyone. Welcome to the Assembly Committee on Judiciary. I'm going to call this meeting to order. Madam Secretary, would you please call the roll?
Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Gonzalez.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Krasner.
Here.
Assemblywoman Marzola.
Here.
Assemblyman Miller.
Here.
Assemblywoman Wynn.
Here.
Assemblyman O'Neill. Assemblyman Orentlicker.
Here.
Assemblywoman Summers Armstrong.
Here.
Assemblyman Wheeler.
Here.
Chairman Yeager.
I am here. That means everyone is here. We have a quorum. Good morning, everyone. Happy Friday morning, and welcome to members, to those guests joining us on the Zoom, and those who may be watching on the internet or the legislature's YouTube channel. Welcome to day 68 of the 81st session of the Nevada Legislature, and welcome to Deadline Friday. Before we get started this morning, just a few quick housekeeping matters. If you're a guest on the Zoom, if you could please be sure to mute yourself when you're not speaking. And if we do go to you for questions on today's work session, if you could make sure to state your name before you speak, that will help us with the minutes. In addition, we do expect courtesy and respect in our interactions with one another. We don't always agree on policy. That's perfectly fine, but we need to make sure we're being respectful of one another, of this process, and of our hardworking staff. Finally, many members will be using multiple devices to access this virtual meeting, so please don't see it as a sign of disrespect or inattention if members appear to be looking away. Okay, committee, with that behind us, we have a work session here, and I'm not sure how many bills we have. I think it might be 18 or so. I'm not going to go strictly in order, only because we have some guests on the Zoom, and I would like to take some of those bills so they can move on with their days accordingly. So. And as a reminder to committee members and members of the public, the work session document is up on Nellis, and under exhibits, each bill has its own work session document. So for those of you who are maybe new to this process, the way that I try to manage what we're doing is I call the bill and then I click on that particular exhibit and it pulls it up in Nellis to be able to look at the work session document. So with that, why don't we first go to Assembly Bill 201. We'll start there. Ms. Thornton.
Thank you, Chairman. Just pulling up the correct page here. For the record, Diane Thornton, Committee Policy Analyst with the Legislative Council Bureau. Our first bill today is Assembly Bill 201. Sponsored by Assemblywoman Gonzalez and heard in committee on March 11. This bill establishes procedures regarding the use of an informant who provides testimony or information on the behalf of the state based on any statement made by a defendant in jail or prison. There's one amendment to this bill sponsored by Assemblywoman Gonzalez, and it does the following. First, in Section 4, it adds in the definition of cooperation agreement. It clarifies in Section 5 the use of the cooperation agreement and that the prosecuting attorney must maintain certain records, including the cooperation agreement. It deletes in Section 6 the word information, revises in Section 6, subsection 1A through G, the material and information that must be disclosed to the defense. Fifth, it revises in Section 6, subsection 4, the jury instruction when the prosecuting attorney uses testimony provided by an informant. And lastly, it deletes sections 7 and 8 of the bill. Thank you, Chairman.
Thank you, Ms. Thornton, and I will let committee members know there's been a lot of work on this bill since we first heard it in committee. I think there's probably still a couple of sticking points that are out there, but I also think it's in a much better place than it was when we heard it. With that being said, does anyone have any questions on Assembly Bill 201 as detailed on the work session document? Let me scroll through and just make sure we don't have questions. Okay, I don't see questions, so at this time I'd be looking for a motion to amend and do pass.
I'll motion to amend and do pass.
I would second that motion.
Okay, we have a motion to amend and do pass from Assemblywoman Gonzalez. I'm not sure who had the second, but we'll give it to Assemblyman Miller this morning. He might have been a little bit quicker on the second. Any discussion on the motion? Assemblywoman Hanson.
Thank you, Chair. I appreciate all the work that Assemblywoman Gonzalez has been doing to try to work with the stakeholders. And certainly I understand the genesis of this bill relates back to the DeMarlo Berry case, which is near and dear to all of our hearts. Not quite there yet, so I'm going to be a no now, but looking forward to seeing this move and get tighter so that more of us can have some comfort with it. So thank you so much.
Thank you, Assemblywoman Hanson. Further discussion on the motion? Assemblyman O'Neill?
I just say ditto.
That's perfectly acceptable, especially on a Friday deadline day. Thank you, Assemblyman
Where are
O'Neill.
the donuts?
They're on the way. Anyone else have discussion on the motion? Assemblyman Wheeler?
Yes, Mr. Chair, actually, just a little sidebar. Power bars are better for us diabetics than donuts, just so you know.
Thank you, Assemblyman Wheeler. I, for one, usually eat both, so it's probably the worst case scenario of those.
Don't give up the donuts. I'm looking for my maple bar now.
Okay, further discussion. I don't see further discussion. So again, what we're going to do is a voice vote on these bills because otherwise I think we'll be here all day. So I would ask committee members if you could unmute yourselves. And at this time, the motion is to amend and do pass. All those in favor, please signify by saying aye.
Aye.
Any opposed, nay?
Nay.
Could I just have a show of hands for the nay really quick? So we have nays from Assemblyman Wheeler, Assemblyman O'Neill, Assemblywoman Hanson, Assemblywoman Kasama, Assemblywoman Hardy. And I think that is all the nays. So the motion does carry. I'm going to assign the floor statement on that one to Assemblywoman Gonzalez.
Thank you,
And,
Chair.
You're welcome. And again, committee, we're going to bounce around just a little bit so our guests can get on the way. So why don't we go to Assembly Bill 341 next? That is the consumption lounge bill, and that work session document was sent a little bit earlier today as we were working through the night to get it ready. So Ms. Thornton, if you could describe that, and then I'll be happy to take any questions.
Thank you, Chairman. Assembly Bill 341 was sponsored by Assemblyman Yeager and heard in committee on April 2nd. This bill provides for the licensure and regulation by the Cannabis Compliance Board of the cannabis consumption lounges. There's an amendment proposed by Assemblyman Yeager, and it does the following. First, it revises provisions in Section 9 defining a social equity applicant. Secondly, it prohibits in Section 10 the board from issuing an adult use cannabis establishment license for a retail cannabis consumption lounge unless the location of the proposed cannabis consumption lounge is in compliance, and deletes the exemption from certain restrictions relating to the location for an attached retail store and consumption lounge. Next, it requires in Section 11 the board to establish regulations for the qualifications to be considered a social equity applicant, including the minimum percentage of ownership by an individual or ownership group as a social equity applicant. Revises provisions in Section 12, subsection 3B, establishing criteria of merit and scoring guidelines to be used in evaluating applications for such licenses. It prohibits the issuance of more than one cannabis consumption lounge license in the same county to an ownership group, individual, or individual with an ownership stake in the group under certain circumstances. Prohibits a cannabis establishment located at an airport. Revises the issuance of adult use cannabis establishment licenses for independent cannabis consumption lounges. Establishes fees for the adult use cannabis establishment licenses for retail cannabis consumption lounges and independent cannabis consumption lounges, and further allows for a reduction in fees for social equity applicants. Revises certain rules set forth pertaining to the safe and healthful operation of cannabis consumption lounges. It replaces in Section 22 the term cannabis or cannabis product with single-use cannabis product. Provides that a cannabis consumption lounge must not allow the removal of cannabis products purchased at a cannabis consumption lounge intended to be consumed at the location where it was purchased. Revises the authorization for a retail cannabis consumption lounge to prepare and sell ready-to-consume cannabis products. Revises terminology concerning the delivery of single-use cannabis products to the customer in the lounge. Requires an independent cannabis consumption lounge to submit a request to the board to sell ready-to-consume and single-use cannabis products to the customers of the lounge. Revises provisions regarding the regulation of the preparation and sale of ready-to-consume cannabis products. Adds a new section amending NRS 678D.310, providing that there's no liability if the person served is 21 years or older. Requires in a new section 38 that the board adopt regulations providing for the gathering and maintenance of comprehensive demographic information. And lastly, it requires that the report to the LCB include recommendations of any statutory changes necessary to ensure that certain violations do not inhibit the growth of independent cannabis consumption lounges. Chairman.
Thank you, Ms. Thornton. And committee, I think this will probably be the longest work session bill we have today. As you can see, there are a number of amendments that have been made. I just wanted to mention a couple things before I take questions. One issue that has come up along the way for us is the issue of odor that might be emanating from these locations. And I want to make clear for the record that cannabis consumption lounges, if they're approved, would have to comply with any local air quality regulations such as nuisance odor, and local authorities could take action on those businesses if they're not in compliance with that. So it's going to be important for those licensees to recognize that when they construct the lounge or think about how it's going to work, they're going to have to take that into consideration, or they're going to make the county very, very unhappy. Other than that, just a super high level overview. We wanted to make clear that these facilities can't be in airports. We wanted to give the CCB in Section 27 some ability to go after anti-competitive behavior in terms of where these lounges might procure product from. So we're still working a little bit through that Section 27 language. I think this will be a work in progress, but we're pretty close to getting there. And then the social equity and ownership of interest, that was a topic that was very important to this committee. So I think some of the language we put in assures that we're doing that in a more fair and equitable manner. But as I noted, committee, well, maybe I didn't note this before, but there is a fiscal note on this bill. So if we pass it out here, I expect it's going to be in Ways and Means for a little while. So, we'll have a chance to try to work out some of those issues there. But I know it's a huge amendment and you just got it a couple of hours ago. So any questions on the work session document for Assembly Bill 341? All right, I don't see questions. I believe Assemblyman Miller wanted to make a motion.
Yes, thank you, Chair. I want to just say thank you very much for working so closely with the cannabis equity and inclusion community on a lot of the language throughout the amendments, and particularly pertaining to social equity. That is a really, really good thing for me and for the community. And so I just want to say thank you for that. And with that, I would like to move that we amend and do pass AB 341 with the amendments.
Thank you, Assemblyman Miller. Do I have a second?
I'll second.
Okay, we had a motion from Assemblyman Miller, a second from Assemblywoman Marzola. Discussion on the motion? Okay, I'm not seeing any discussion. So again, members, if you could unmute yourself, please. The motion is to amend and do pass Assembly Bill 341. All those in favor, please signify by saying aye.
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 Do we have any opposed? If so, please say nay.
Nay.
So,
Okay, so can I get a show of hands on the nays, please? We have noes from Assemblyman Wheeler, Assemblyman O'Neill, Assemblywoman Krasner, and Assemblywoman Hanson. So there are 4 noes. Motion does carry. Assemblywoman Gonzalez, did you have
I
your
have a
hand up?
question. I'm sorry. No.
Okay, thank you. I'll be happy to answer questions afterwards since we already took the motion, if that works, if it's on this bill.
I just can't find it on the work session document. So I just wanted to make sure that I didn't miss it.
If you are on
341, right?
341, so
Okay.
this was one that was sent out maybe about an hour or 2 ago this morning.
Okay.
So it may be in a different email, but it is up on Nellis under exhibits.
No worries. I was just trying to find it. I apologize. Thank you so much.
No problem at all. I know things are moving pretty fast this morning. So again, the motion does carry, and I'll take the floor statement on Assembly Bill 341. So with that, really big one behind us. Let's just take a couple more of these out of order so we can have some of our guests get along with their day. Let's go next to Assembly Bill 440, please, Ms. Thornton.
Thank you, Chair. Assembly Bill 440 is sponsored by this committee and heard in committee on April 6th. This bill provides that a peace officer must issue a person a misdemeanor citation instead of executing a warrant by arresting the person unless the warrant is used for an offense that constitutes an aggregate offense or a crime of violence. There's one amendment proposed to this bill by Senator Dallas Harris, and it does the following. First, it removes all references to aggregate offense and replaces it with subsequent offense. It adds a definition of subsequent offense, deletes Section 5, amends Section 6 to clarify the circumstances when a person must be taken before a magistrate, and lastly, amends Section 7 to clarify the circumstances when a citation may be used.
Thank you, Ms. Thornton. Committee members, you may recall, I think we heard this bill, I think it was this week, but frankly, I can't remember. But there were a number of concerns that were raised at the hearing, and Senator Harris is here with us this morning. And as you see, that amendment she provided, I think does address many of those concerns, but certainly would give committee members a chance to ask any questions about Assembly Bill 440 as detailed on the work session document. Are there any questions this morning? All right, I don't see questions, so at this time I would look for a motion to amend and do pass.
I'll move to amend and do pass.
I'll second.
I have a motion from Vice Chair Wynn, a second from Assemblywoman Gonzalez. Do we have discussion on the motion? If so, if you could raise your hand. I don't see discussion on the motion, so committee members, again, want to ask you to unmute yourself, please. And the motion is to amend and do pass Assembly Bill 440. All those in favor of that motion, please signify by saying aye.
Aye.
Aye. Aye.
If there are any opposed, please say nay.
Nay.
And could I just have a show of hands for who our nays were? So our nays are from Assemblywoman Kasama, Assemblyman O'Neill, Assemblywoman Hardy, Assemblywoman Hanson, Assemblywoman Krasner, and Assemblyman Wheeler. So we have, I think that's 6 nays if I counted correctly, but the record will reflect that that there were enough votes to pass. So the motion does carry on Assembly Bill 440. And what I'm thinking I'm going to do on that one is I'll assign Vice Chair Wynn, Assemblyman Flores presented the bill, but I'll assign Vice Chair Wynn to do the floor statement. And Senator Harris, thank you for working on the amendment and thank you for being available this morning.
Thank you so much, committee. Have a great day.
Thank you, you too. I think that means, actually, I know, Ms. Thornton, I'm throwing you a couple of curveballs here this morning, but if we could go next to Assembly Bill 405, which is the gaming bill that we heard yesterday. Let's go ahead and take that one when you're ready, Ms. Thornton.
Thank you, Chair. Assembly Bill 405 is sponsored by this committee and heard on April 8th. This bill revises several provisions relating to gaming, and there are 3 proposed amendments to the measure. First, Tanner Britton from the William Boyd School of Law proposed an amendment adding the language coach in Section 5, subsection 10. Secondly, George Hartline, also of the William Boyd School of Law, proposed deleting Section 2 of the bill. And lastly, Assemblyman Yeager proposed deleting Sections 1, 3, and 4 of the bill.
Thank you, Ms. Thornton. And we do have Mr. Hartline is on the Zoom with us this morning as well. And just to give the committee members a kind of a little bit of a background, I had some further discussions about the bill, and I think this is, in my belief, the best way to move the bill forward now, realizing that many of the sections are coming out of the bill. I have committed to talk with the Senate Judiciary Chair to see if the students can still be accommodated and present over in the Senate Judiciary if this bill is to get there. So I didn't want to give anyone the impression that those students would be locked out of further participation in the process. We'll try to accommodate that over in the Senate Judiciary Committee, see if I have any influence over there. Hopefully for all of us, I have a little bit. Any questions on Assembly Bill 405 as detailed in the work session document? I don't see questions, so at this time I'd be looking for a motion to amend and do pass.
Also,
But that was a close one. I think I'm going to give it to Assemblyman Wheeler, and I think I heard Assemblyman O'Neill. So we'll give Assemblyman Wheeler the motion, Assemblyman O'Neill the second on the motion. Is there any discussion on the motion? I don't see discussion. Do want to thank Mr. Hartline for being here this morning and for participating in the hearing yesterday. We appreciate it.
Glad to be here. Anything you need from me, I'm here for you.
Thank you, sir. So again, the motion is to amend and do pass. If members could unmute themselves, please. All those in favor of the motion, please signify by saying aye.
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 If anyone is opposed, would you please say nay? Okay, motion carries unanimously. And I suppose, Assemblyman Wheeler, would you like the floor statement on that one? Okay, let's give the floor statement to Assemblyman Wheeler on Assembly Bill 440. Now, I think what we can do is take the bills from the top as listed on the work session agenda, which will make Ms. Thornton's life tremendously easier this morning. So, Ms. Thornton, if we could go back to the beginning of the agenda, and we'll go with Assembly Bill 116, and then we'll take the rest in order.
Thank you, Chair. Assembly Bill 116 is sponsored by Assemblywoman Nguyen and heard in this committee on March 18th. This bill establishes civil penalties for certain traffic and related violations. And Assemblywoman Nguyen proposed an amendment. There's a detailed conceptual amendment on the following pages. Thank you, Chair.
Thank you, Ms. Thornton. And what I wanted to do on this one, committee, you remember this is a traffic citation bill. And so there are quite a few amendments, and I wanted to hand it over to our vice chair to just do a high-level explanation of what the amendment seeks to accomplish based on the feedback that was given at the hearing on Assembly Bill 116, and then I'll take some questions after that. So, Vice Chair, please go ahead.
Thank you. And I just wanted to start off by saying that obviously it's a large document of proposed conceptual amendments, and I really want to thank all of the stakeholders. They really worked really hard to be able to get this. It also taught me to kind of go with my instincts, and also I will remind everyone that it's important to include those people at the localities that are actually doing the work. I think what I was shocked by is when I met with court administrators and other municipal staff and county staff across the country or across the state. They were like, this is the first time any legislator has ever reached out to me. Usually we just are told what we have to do, and then we have to find ways to fix it. So I really do appreciate their impact. So some of the things and their impact and their involvement in making this bill what it is here today. I think, there, as John Jones said in his support testimony during Assembly Bill 116, no bill is going to be perfect, and I guarantee we are going to continue to work. I know we still have ongoing working groups because while people feel very comfortable with the language that we've come up with in these proposed amendments, I am sure as we distribute this language and people get a better chance to look at it, we'll be coming back with some additional amendments to further clarify this. Some of the big things that we worked on that we were able to incorporate in this bill is carving out those traffic matters that we never intended to be traffic, vehicular manslaughter, DUI, reckless driving, hit and run. In fact, there's quite an extensive list of charges that are carved out of civil infractions. And even within civil infractions, some of the amendments also incorporate the fact that if you are charged with something, it could go there. There's 14 pages. I don't know. I'm just going to kind of leave it there. And then the monetary piece, we wanted to ensure that we have a structure in place where that money stays with the courts so they are not taking the financial hit that other previous legislation had previously contemplated. So we're still working on it. If you have any other questions, let me know. I see your white flag there, Assemblyman Wheeler. I almost should have had Diane just read it all.
I think we're all voting yes. You can move on.
All right, thank you so much, Vice Chair Nguyen. Committee members who were here last session might be having some deja vu because I feel like we were in the same position last session with this bill, having a lot of work to be done, but I think it's way further along than we ever got last session. So thank you, Vice Chair Nguyen, and those who worked on it. Any questions for Vice Chair Nguyen? Don't see questions, so I'll be looking for a motion to amend and do pass.
A motion to amend and do pass.
I'll second.
So I think I have a motion from Assemblywoman Gonzalez, and I saw Assemblywoman Hardy raise her hand, so we'll give her the second on that. Is there discussion on the motion? Assemblywoman Hanson.
Sorry, I know there's lots of bills and you're getting tired of hearing from me. This one, I'm on the policy. Yes, yes. And I'm going to be a yes here on policy. We always are lectured that these are not money committees. There are big fiscal impacts as it stands, but I'm so glad you're working with those in the trenches. I know some of my communities have large fiscal notes, so I'm yes on the policy and hoping the fiscal issues might be able to be resolved and have more input as you work this bill further. So thank you for all the hard work you're doing and talking to the local communities that these will impact in our cities and counties. Thank you so much.
Thank you, Assemblywoman Hanson, and there's no problem at all for discussion. That's what we're here for, and that's why we didn't put any bills for hearing on this morning's agenda, so we had ample time to go over these. Any further discussion on the motion? Okay, don't see further discussion. Committee members, if you could unmute yourself, please. The motion is to amend and do pass Assembly Bill 116. All those in favor, please signify by saying aye.
Aye.
Any opposed, nay? Okay, we don't have any nays that I heard, and I don't see anyone raising their hand, so that motion does carry unanimously. Congratulations, Vice Chair Wynn. I will assign you the floor statement, and good luck the rest of the way on this one. Let's go next to Assembly Bill 132, please.
Assembly Bill 132 is sponsored by Assemblyman Flores and heard in committee on March 9th. This bill required a peace officer or probation officer to make an electronic recording of any custodial interrogation of a child under 15 years of age who is suspected of committing certain acts. Assemblyman Flores proposed an amendment which does the following. It deletes the language in the bill and replaces it with a new Miranda warning for children. Thank you, Chair.
Thank you, Ms. Thornton. And we do have Mr. Pirro here if anyone has questions about the amendment, but so let me ask that. Does anyone have questions about Assembly Bill 132 as detailed in the work session document? I don't see anyone raising their hand for questions, so at this time I'd be looking for a motion to amend and do pass.
Make a motion to amend and do pass.
Have a motion, do I have a second?
Second.
The motion to amend and do pass from Assemblywoman Bilberry Axelrod, a second from Assemblywoman Summers Armstrong. Any discussion on that motion? Seeing no discussion, members, please unmute yourselves. The motion is to amend and do pass Assembly Bill 132. All those in favor, please signify by saying aye.
Aye.
Is there anyone who's opposed? If so, please say nay.
Nay.
Okay, if you could raise your hand as well. I see Assemblyman O'Neill is a nay, Assemblyman Wheeler is a nay. I don't see other hands up, so we have 2 nays. The motion does carry. I'm going to assign the floor statement on that one to Assemblyman Flores. And just in case he is not able to handle that for some reason, I'll have Assemblywoman Bilberry Axelrod as a backup. Let's take Assembly Bill 141 next.
Chair, Assembly Bill 141 was sponsored by Assemblyman Watts and heard in committee on March 4th. This bill increases the length of notice required before certain tenants may be evicted without cause, including week-to-week tenancies and other periodic tenancies. There's an amendment to the bill sponsored by Assemblyman Watts, and this amendment revises the existing law that automatically seals eviction records under certain circumstances. This amendment would extend the sealing of records to evictions for non-payment of rent that occurred during the COVID emergency, beginning on March 20th, 2020, and ending when the governor terminates the state of emergency. Thank you, Chair.
Thank you, Ms. Thornton. Committee members, any questions on Assembly Bill 141 as detailed on the work session document? I don't see questions at the moment. I will take a motion to amend and do pass.
I'd so move to amend and do pass.
Is there a second?
I'll second.
Motion to amend and do pass from Vice Chair Wynn. I believe the second was from Assemblyman Miller. Any discussion on the motion? I don't see discussion. Committee members, if you could please unmute yourself. The motion is to amend and do pass Assembly Bill 141. All those in favor, please signify by saying aye.
Aye.
If there's anyone opposed, could you please say nay?
Nay.
And could I have a show of hands on the nays, please? So we have nays from Assemblywoman Kasama, Assemblyman O'Neill, Assemblywoman Hardy, Assemblywoman Hanson, Assemblywoman Krasner, Assemblyman Wheeler. So there are 6 nays. That means there are 9 in favor. Motion does carry. I'll assign the floor statement on that one to Assemblyman Watts. Just in case he needs a backup, we'll list Assemblywoman Summers Armstrong as a backup on Assembly Bill 141. Moving right along, we already did Assembly Bill 201, so let's go next to Assembly Bill 243.
Thank you, Chair. Assembly Bill 243, sponsored by Assemblyman Ornlicker. This bill creates and establishes the duties of the Nevada Police Reform Advisory Task Force, and it also requires the court to consider the differences between youthful and mature adult offenders in determining the appropriate sentence for a person convicted of a crime committed when he or she was less than 21 years of age. It also establishes a race-blind charging system. An amendment proposed to this bill. Assemblyman Ornlicker proposed an amendment which does the following. First, it deletes sections 1 through 6 of the bill, removing the task force. Secondly, allows each prosecutorial office to establish a system of race-blind charging to be used when determining whether a criminal charges should be filed against a person. It also allows each district attorney to establish a system of race-blind charging to be used when determining whether to file or not file a petition alleging a child is delinquent. And lastly, it amends the effective date of the bill. Thank you, Chair.
Just wrong.
Thank you, Ms. Thornton. Any questions on Assembly Bill 243 as detailed in the work session document? I don't see any questions. I would take a motion to amend and do pass.
I'd move to amend and do pass.
Do I have a second?
Second.
We have a motion to amend and do pass from Vice Chair Wynn, a second from Assemblyman Miller. Is there any discussion on the motion? Before we vote, I did want to thank Assemblyman Ornlicker for his work on this bill. I do appreciate it. I know it took a while to get to where we are, but I wanted to thank you for that hard work. Again, the motion is to amend and do pass Assembly Bill 243. If you could all please unmute yourself. All of those in favor of the motion, please signify by saying aye.
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 If there is anyone opposed, would you please say nay?
Nay.
Nay.
Okay, could I get a show of hands on the nays, please? Nay, we have no's from Assemblywoman Kasama, Assemblyman O'Neill, Assemblywoman Hardy, Assemblywoman Krasner, Assemblywoman Hanson, and Assemblyman Wheeler. 6 nays, 9 in favor. Motion does carry. Assemblyman Ornlicker, I will obviously give you the floor statement on the bill. Congratulations. Let's figure out where we are. So we'll go next to Assembly Bill 251, please.
Assembly Bill 251, sponsored by Assemblywoman Krasner and heard in committee on March 16th. This bill requires a peace officer or a probation officer to ensure that a child in custody consults with a parent or guardian or an attorney before the commencement of a custodial interrogation of the child. There's two amendments proposed to this bill. First, Assemblywoman Krasner proposed adding certain sponsors to the bill. Secondly, Bridget Duffy from the Nevada District Attorneys Association proposed an amendment that does the following. It first deletes section 1, 2, 3, 7, 8, and 9 from the bill. It adds provisions in section 4, subsection 1, to provide that the age of 18, a person may petition the court for the expungement of their juvenile record for misdemeanors or acts of a child in need of supervision. Next, it provides a definition of expungement. It requires in section 4, subsection 3, the juvenile court to notify the district attorney, the chief probation officer, or the chief of the Youth Parole Bureau if a petition is filed. It provides that certain persons who have evidence relevant to the consideration of the petition may testify at the hearing. Provides in section 4, subsection 5, that if a juvenile court enters an order to expunge a child's record, it must be done within, I think there's a typo there. Adds a new section 10 to the bill that provides for the automatic sealing of records when a child reaches 18 years of age under certain circumstances. Provides in a new section 11 that the effective date for section 4 and 10 is December 31st of 2021. And Chair, can you confirm the dates on that? The time period on that one amendment?
Yes, Ms. Thornton, let me take a quick look.
Section 4, subsection 5.
It's 60 days.
Thank you. Thank you. And so that one's on me too, committee. I reviewed these documents and I missed that typo on there. So it's supposed to be 60 days. Before I open it up for questions, I did just want to make a statement for the record. Mr. Ortiz from Clark County, you may remember, I believe he weighed in on the bill at the time of the hearing. He has provided an email to myself and to Assemblywoman Krasner, letting us know that if the committee, in fact, does pass the bill with the amendment as described, that Clark County would be withdrawing its fiscal note on the bill. So I want to put that on the record, and Assemblywoman Krasner, you have that email as well. So make sure you hold on to that for the bill as it moves forward, as you may need that. Any questions on Assembly Bill 251 as described in the work session document? Assemblywoman Krasner, did you have a question or did you want to make the motion?
I just had some comments whenever the appropriate is, Chair.
Great. Let me take the motion first and then we'll do comments. So I'll take a motion to amend and do pass.
I'll move.
I'll second.
Vice Chair Wynn has made the motion. Assemblywoman Gonzalez has seconded the motion. Assemblywoman Krasner, discussion?
Thank you, Chairman Yeager. This bill, AB 251, has had multiple meetings. Whoever was here last session and participated in the woodshed meetings knows what I'm talking about. We've had so many meetings with so many stakeholders. We finally have come to a position where all are in support. The fiscal note has been removed. I'd like to thank Kendra Birchie, Washoe County Public Defenders, John Puro, Clark County Public Defenders, Bridget Duffy, Assistant District Attorney, Clark County, Jennifer Noble, Elizabeth Flores, Washoe County Department of Juvenile Services, Alex Ortiz, Mike Wellahan, Department of Juvenile Justice Services, Clark County, and so many more people. The District Attorney Association, with Bridget Duffy's help, was so kind to create the actual amendment that you do see on Nellis, and just thank you to all of you for your support. Thank you, Chair Yeager, for your patience also in this bill. Appreciate it so much.
Thank you, Assemblywoman. I appreciate your hard work on this bill. I'm glad we were able to get it into a place where it seems to work for everybody. Are there any other further discussion? Assemblyman Wheeler?
I just wanted to say, Mr. Chair, that I was a very hard no on this bill as presented, but with all the amendments and the Assemblywoman working with the interested parties, I'm going to swing over and be a yes on it.
Thank you, Assemblyman Wheeler. Further discussion on the motion? Okay, I don't see further discussion. If everyone could unmute themselves, please. The motion is to amend and do pass Assembly Bill 251. All those in favor, please signify by saying aye.
Aye.
Aye. And if there is anybody opposed, would you please say nay? I don't hear or see any opposition, so motion does carry unanimously. Congratulations, Assemblywoman Krasner. I'll give you the floor statement. And up next, we have Assembly Bill 296.
Thank you, Chair. Assembly Bill 296 was sponsored by Assemblywoman Wynn and heard in committee on March 8th. This bill establishes and sets forth the elements of the crime of doxing. There is an amendment proposed by Assemblywoman Wynn, and it does the following. First, it deletes sections 1, 9, and 10 of the bill. It changes the spelling of doxing. It revises the definition of unlawful doxing of a person in section 6, deletes the criminal punishments in section 6, subsection 2, clarifies that these provisions do not apply to certain dissemination of information, deletes the criminal penalties, clarifies that these provisions will not be construed to conflict with certain federal law, and lastly, deletes certain definitions, including harassment and substantial life disruption, and adds the definition of mental anguish. Thank you, Chair.
Thank you, Ms. Thornton. Committee, remember we heard this bill yesterday, which seems like 48 or 96 hours ago at this point, but I think the amendment reflects some of that further work that was going to be done on the bill after the hearing. Any questions for Vice Chair Wynn on the work session document on Assembly Bill 296? I don't see any questions. At this time, I'll take a motion to amend and do pass.
I
Assemblyman
motion
Wheeler?
to amend and
So
do-
moved.
So Assemblyman Wheeler made the motion to amend and do pass. I saw Assemblywoman Gonzalez unmute. Would you like to second the motion?
I'll second.
Okay, so I have a motion and a second. Is there any discussion on the motion? Assemblywoman Hanson?
Well, this is really difficult. The changing of the spelling has caused me to question my support of the bill, but I will just stuff that and support the bill, the spelling.
I feel like you were just dropping docs on us there, Assemblywoman Hanson, but we'll take it this morning. Any further discussion on the motion? I don't see further discussion. Members, if you could please unmute. The motion is to amend and do pass Assembly Bill 296. All those in favor, please signify by saying aye.
Aye.
If there is anyone opposed, would you please say nay? I don't hear or see any nays. The motion does carry unanimously. I'll assign the floor statement to Vice Chair Wynn. Congratulations. That takes us next to Assembly Bill 339.
Assembly Bill 339, sponsored by Assemblywoman Wynn and heard on March 23rd in committee. This bill authorizes a justice court or municipal court to establish a program for the treatment of defendants convicted of misdemeanor battery, which constitutes domestic violence. There is one amendment proposed to this bill by Assemblywoman Wynn. First, it allows the victim to be heard prior to assigning the defendant to the program of treatment. It provides limitations on the defendant's eligibility to the program of treatment, provides upon fulfillment of terms and conditions, the court may conditionally dismiss the proceedings, deletes language in Section 4 concerning the discharge and dismissal and replaces it with language concerning the provisions of the conditional dismissal. The amendment also provides that the records are confidential and will not be sealed until 7 years have passed since the defendant was discharged. Thank you, Chair.
Thank you, Ms. Thornton. Any questions on Assembly Bill 339 as detailed on the work session document? I don't see questions. At this time, I'll take a motion to amend and do pass.
Also move, Chair.
We have a motion from Assemblyman O'Neill. Do we have a second? Do we have a verbal second?
I'll second.
Second, I was talking, sorry. Second.
I'm not really sure who seconded, but here's what we'll do. We'll give Assemblyman O'Neill the motion to amend and do pass. We'll give Assemblywoman Wilbur Axelrod the second. I think we had several seconds there, but that's how we'll put it down in the minutes. Any discussion on the motion? Assemblywoman Cohen.
Thank you, Chair. I had raised some issues during the hearing regarding the effect of this on domestic cases, and I appreciate that the Vice Chair has continued to work on that issue. And I know it might not quite be where I think it needs to be, but as I said, I know she's still working on it, and I appreciate that, and I'm confident that it will get there. So thank you.
Thank you, Assemblywoman Cohen. Further discussion on the motion? I'll just say, Vice Chair, you have been very, very, very busy this session. Seems like every other bill is one of yours and has had a lot of amendments. So thank you for continuing to work on these bills. I know
I think I made terrible decisions.
Yeah, she might be regretting deciding to carry so many of these bills, but hopefully the hard work that you've been putting in will pay off as they move forward. Okay, further discussion on the motion. I don't see further discussion. If members could unmute themselves. The motion is to amend and do pass Assembly Bill 339. All those in favor, please signify by saying aye.
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 If there is anyone opposed, would you please say nay? I don't hear or see any opposition. Motion carries unanimously. Vice Chair, that floor statement is going to be yours as well. Congratulations. Okay, committee, we've already done Assembly Bill 341, so let's move on to Assembly Bill 342.
Assembly Bill 342 is sponsored by this committee on behalf of the Sunset Subcommittee of the Legislative Commission and heard on March 24th. This bill revises the frequency of review of standards adopted by the State Board of Parole Commissioners. The bill also transfers from the board to the sentencing court all current duties and responsibilities relating to lifetime supervision of sex offenders for sex offenders sentenced on or after July 1st, 2021. There's one amendment proposed by Christopher Dorico, Chair, State Board of Parole Commissioners. The amendment revises in Section 1 how often the board must comprehensively review its adopted standards. It deletes the notification requirement to the Central Repository for Nevada Records of Criminal History if a court issues a warrant for the arrest or a violation. This is deleted because a violation of a condition of lifetime supervision is a new crime and not a violation for which a warrant may be issued. Third, requires that at the time of sentencing, the court shall impose the conditions of lifetime supervision, provides that the evaluator must be a licensed clinical professional who has received training in the treatment of sex offenders, and lastly, it deletes the definition of person professionally qualified to conduct psychosexual evaluations from the lifetime supervision statutes. Thank you, Chair.
Thank you so much, Ms. Thornton. Before I take questions, I wanted to let committee members know that I've been privy to a number of discussions on this bill between Chair Dorico, our prosecutors, and our public defenders. They are working hard on the bill. I don't think everyone is yet at a place where they're enthusiastic about the bill, but everyone is in agreement that the bill should continue to move forward and they can continue to work on some of the language changes. Chair Dorico has committed to doing that, as have the other interested parties. So I don't think we have any of them on the Zoom, but I want to let the committee know that that's kind of where things are at the moment. So with that being said, are there any questions on Assembly Bill 342 as detailed in the work session document? Okay, I don't see questions. At this time, I would take a motion to amend and do pass.
I'd move to amend and do pass.
Do I have a second?
I'll second.
Okay, so I have a motion to amend and do pass from Vice Chair Nguyen, a second from Assemblywoman Cohen. Any discussion on the motion? I don't see discussion. If members could please unmute themselves. The motion is to amend and do pass Assembly Bill 342. All those in favor, please signify by saying aye.
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 Aye. If there is anyone opposed, please say nay.
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 Okay, can I have a show of hands on the nays, please? We have nays from Assemblywoman Kasama, Assemblyman O'Neill, Assemblywoman Hardy, Assemblywoman Kresner, Assemblywoman Hanson, Assemblyman Wheeler. That would mean 6 nays, 9 in favor. Motion carries. And I'll take the floor statement on that one, committee. That takes us next to Assembly Bill 395.
Assembly Bill 395, sponsored by this committee and heard on March 31st. This bill abolishes the imposition of a sentence of death on a person convicted of first-degree murder, and there are no proposed amendments to this measure. Thank you, Chair.
Thank you, Ms. Thornton. This one might be the shortest work session document we have on today's agenda. Are there any questions about the work session document on Assembly Bill 395? Okay, I do not see questions. At this time, I'll take a motion to do pass.
I'll move to do pass.
Do I have a second? All right, so I have a motion to do pass from Vice Chair Nguyen, a second from Assemblywoman Gonzalez. Is there discussion on the motion? All right, I don't see discussion on the motion. Members, ask you to please unmute yourselves. The motion is to do pass Assembly Bill 395. All those in favor, please signify by saying aye.
Aye.
Aye. And for those opposed, please say nay.
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 Could I have a show of hands on the nays, please? Okay, I'm going to get good at this. So the nays are from Assemblywoman Kasama, Assemblyman O'Neill, Assemblywoman Hardy, Assemblywoman Kresner, Assemblywoman Hanson, Assemblyman Wheeler. That would be 6 nays, 9 in favor. Motion carries. And I'll take the floor statement on that one as well. That moves us to Assembly Bill 400, please.
Assembly Bill 400, sponsored by this committee and heard on March 29th. This bill revises provisions relating to prohibited acts concerning the use of marijuana and the operation of vehicle or vessel. There is an amendment to this bill sponsored by Assemblyman Yeager. This amendment proposes decoupling the driving and under the influence statutes with the workers' compensation statutes by importing the table in NRS 484C.110, subsection 3 and subsection 4A into 616C.230. Thank you, Chair.
Thank you, Ms. Thornton. Before I take questions, I'll just explain a little bit about what this amendment does. Committee, you may remember when we heard this bill, there was some concern expressed by employers and about testing of employees if we changed the statute. And at that time, what I indicated was our workers' compensation statutes actually refer back to the DUI statute. They don't have a chart in the workers' comp statute. So in working with some of the larger employer groups and some of those who express concern, what we decided to do is take the chart that exists and put it into the workers' comp statute. So the 2 nanograms of THC would still apply in the workers' comp context. And so that would mean if someone was tested because of a work-related injury, that if they were over the 2 nanograms of active THC, that their claim would be presumptively denied. I can tell you that the larger employer groups I talk to are on board with that amendment. The one sticking point we still have, and I raise this mostly for Assemblyman O'Neill's benefit, is this idea of federal funding and commercial driver's licenses. I'm still working with the Department of Motor Vehicles and some of the construction companies to work through those issues. I don't believe there is a jeopardization to federal funding because nothing in the bill would prevent a blood test for this, and folks could still be held accountable for driving impaired. But that being said, I've committed to continuing to work with the Department of Motor Vehicles and other interested parties to figure out whether we need to put some kind of additional language in the bill just to make that abundantly clear, because I don't want to jeopardize anything we do on the federal level. We need every dollar we get in the state. So that's where we are with the bill. There could be some further clarifications on that regard moving forward, but I think I was able to at least satisfy the concerns raised by your more traditional non-highway fund, non-construction employers. So I know that was a long explanation for a very short amendment. Any questions on Assembly Bill 400 as detailed in the work session document? I don't see questions, so at this time I would take a motion to amend and do pass.
I'd so move to amend and do pass.
Second.
We have a motion to amend and do pass from Vice Chair Wynn, a second from Assemblywoman Summers Armstrong. Is there any discussion on the motion? Assemblyman O'Neill.
Chair, I just want to thank you very much for your attempts to work with DMV, et cetera, on the issue. I'll be voting no for now, and hopefully we can get to a point where I can go yes for it. Thank you, Chair.
Thank you, Assemblyman O'Neill. Appreciate that. I appreciate you approaching me with those concerns. I'm confident we'll get them worked out. Just didn't get it worked out by today, but we'll keep working on it. Is there other discussion on the motion? All right, don't see any further discussion, so I would ask members to unmute themselves. The motion is to amend and do pass Assembly Bill 400. All those in favor, please signify by saying aye.
Aye.
Aye. Any opposed, please say nay.
Nay.
Okay, could I have a show of hands on the nays, please? We have nays from Assemblywoman Kasama, Assemblyman O'Neill, Assemblywoman Hardy, Assemblywoman Krasner, Assemblywoman Hanson, Assemblyman Wheeler. 6 nays, 9 in favor, motion carries. And I suppose I ought to take that floor statement as well. I'm going to try to give the rest of them to other people. So thank you, committee. We have already covered Assembly Bill 405, so we'll move next to Assembly Bill 406.
Thank you, Chair. Assembly Bill 406 was sponsored by this committee and heard on March 30th. This bill revises provisions relating to the collection of child support. There is one sponsored amendment for this bill, sponsored by John Jones, Chief Deputy District Attorney, Clark County. He proposed clarifying that the gambling winnings due to the obligor may be withheld for the support of a child pursuant to NRS 31A.025 through 31A.190. The amendment does the following. It deletes Section 1 of the bill and maintains the definition of gambling winnings. Thank you, Chair.
Thank you, Ms. Thornton. And committee, just as a note of explanation, this was the bill that would have required certain gaming establishments to run folks' names in the database and hold winnings. And you may remember from the committee hearing that the effective date of the bill was going to be a couple years out yet. In fact, it would not have gone into effect until the next I think, till after the next legislative session. So in speaking with the sponsor and other interested parties, I think we decided it was best not to implement that part at this time, but let parties continue to work on it and make sure that the database that could be queried was going to be up and functional. But that being said, all the parties agreed to keep Section 2 of the bill, which makes a clarification that gambling winnings or contest does in fact mean gambling winnings, but it would not impose any requirement on our gaming partners to withhold that money. It would still be up to the department to do it. So that's what's happening in Assembly Bill 406. I have not received any opposition, heard of any opposition to how it's detailed on the work session document. Any questions from committee members on Assembly Bill 406 as detailed? I don't see questions. Assemblyman Wheeler, please go ahead.
All right, Mr. Chair, I may have just missed that. Did you say the Resort Association removed their objection to this bill?
Yes, Assemblyman Wheeler, they were in agreement with keeping Section 2 of the bill, and they were also committed to continue working on Section 1 through the interim up to the next legislative session. Any further questions from committee members? Don't see further questions. Would take a motion to amend and do pass.
Also move.
Do you have a second?
I'll second.
Oh. The verbal second wins over the raised hand. So the motion will be from Vice Chair Wynn. The second will be from Assemblyman O'Neill. Any discussion on the motion? Don't see any discussion. Members, if you could please unmute yourselves. The motion is to amend and do pass Assembly Bill 406. All those in favor, please signify by saying aye.
Aye.
If there's anyone opposed, please say nay. Not hearing or seeing any nays, the motion carries unanimously. And who will I assign that floor statement to? I'm going to assign it to Assemblyman O'Neill. That was his reward for seconding the motion. That takes us to Assembly Bill 414.
Assembly Bill 414, sponsored by Assemblyman O'Neill and heard in committee on April 5th. This bill revises provisions governing the transfer of real property pursuant to a deed becoming effective upon the death of a grantor. There is one amendment proposed. Assemblyman O'Neill proposed making the following changes. First, it provides that after the death of the grantor, a copy of the notice must be mailed to the grantor's personal representative and to the Department of Health and Human Services. Next, it revises subsection 4 so that the notice to creditors includes the date of birth. It adds in subsection 5 the word entity regarding a claim against a grantor or the probate estate, and adds language regarding the waiver of claim subsequent to the written notice to DHHS. It revises subsection 6 by allowing DHHS to secure future recovery of benefits. It clarifies that in subsection 7 that this section does not apply to claims originating with DHHS. It changes in subsection 8 the must to a may concerning title companies recognizing the notices. Further, a title company is not liable for claims that they are not made aware of by the beneficiaries. And lastly, it amends subsection 9, provide that under certain circumstances, a person dealing with a beneficiary of a deed upon death has the same rights and protections as the person would have if the beneficiary had been named as a distributee of the property in order for the distribution of the grantor's estate had it become final. Thank you, Chair.
Thank you, Ms. Thornton. Committee, doesn't it seem like 3 weeks ago that we heard this bill? It was just Monday, so that's how long the week has been. Any questions on Assembly Bill 414 as detailed in the work session document? I don't see questions. I'll take a motion to amend and do pass.
I'd move to amend and do pass.
Ooh, that was a close one. I'm going to give Assemblyman Wheeler that one just because Vice Chair Wynn's made a lot of motions today. So we'll give her the second on this one. And before I take discussion, I did just want to thank Assemblyman O'Neill. I know he's been hard at work with all those who offered opposition testimony to the bill. And I do believe that there is no longer any opposition to the bill. So well done, Assemblyman O'Neill, and thank you for doing that hard work this week. Assemblyman O'Neill, would you like to make any comments?
Yes, I'd just like to say this goes to proof once again that there's no such thing as a simple bill. I learned the hard way. Thank you, Chair, for the compliments, though. It was exciting. Plus, I wanted to be in competition for the longest amendment.
Thank you, Assemblyman O'Neill. Is there further discussion on the motion? Everyone's little bubble just got larger on my screen, which means we must have lost somebody who was on with us. So it's nice to see you all a little more up close and personal. Seeing no further discussion on the motion, if members could please unmute themselves. The motion is to amend and do pass Assembly Bill 414. All those in favor, please signify by saying aye.
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 If there is anyone opposed, would you please say nay? I don't hear any nays. That means the motion carries unanimously. Congratulations, Assemblyman O'Neill, and you, of course, can have the floor statement on Assembly Bill 414. Let's go next to Assembly Bill 424.
Assembly Bill 424 was sponsored by this committee and heard on April 6th. This bill revises provisions relating to pretrial release. There is an amendment sponsored by Assemblywoman Nguyen. The conceptual amendment is on the following page. Thank you, Chair.
Thank you so much, Ms. Thornton. Vice Chair Nguyen, I wanted to give you a moment as well. I know you've done a lot of work on this bill. If you wanted to maybe hit just a couple of the highlights that are in the amendment that appears on the work session document, I think that would be helpful for committee members.
The big one that was contentious that people had concerns about was Section 5 of the bill. With the proposed amendment, and I apologize for the untimeliness of it, I was working on it all last night, so it went up this morning. It deletes that entire section. So this proposed amendment deletes Section 5. Section 8, it allows for telephonic review to determine custody status of a person. We're working with legal to figure out how to incorporate that. That just allows like our rural counties and our courts that don't have, as many cases or the ability financially to be able to hold court to be able to do those telephonically. There's a bunch of amendments that just come in line with the language of that Jimenez-Valdez case that from the Nevada Supreme Court, and it codifies it more specifically using the actual language from that decision. And then the one change is with the timeliness and promptness of going before a judge if you are arrested within 24 hours. It is something that we are continuing to work on to make sure that it is in a better place. It is in a much better place than it was when it started. And I will continue to work with stakeholders as we move through the process.
Thank you so much, Vice Chair Nguyen. Any questions from committee members on Assembly Bill 424 as detailed in the work session document? Assemblyman Wheeler.
Thank you, Mr. Chairman. I just wanted to say that I kind of like the idea of the bill, but these huge unfunded mandates have just pushed me the other way. I'm going to have to go no. Thank you.
Thank you, Assemblyman Wheeler. We are on questions. Any questions for Vice Chair Nguyen? I don't see questions. I'll take a motion to amend and do pass.
Motion to amend and do pass.
Do I have a second?
Second.
Okay, we have a motion from Assemblywoman Gonzalez. We have a second from Assemblyman Miller. We have the prior comment from Assemblyman Wheeler. Is there further discussion on the motion? Let's go to Assemblywoman Hanson and then Assemblyman O'Neill.
Thank you, Chair. And again, I'm going to defer back to what I did with 116. I support this policy. People are innocent till proven guilty, and trying to navigate this bail issue has been something I have wrestled with since my first session in 2019. And so on the policy, I'm going to be yes in committee, hoping to revisit some of these fiscal issues before the floor. But certainly I thumbs up for the policy. I appreciate the work the chair is doing. Been so impressed with her engagement with so many stakeholders. Maybe this will be the session to get there, but thank you again for the work.
Thank you, Assemblywoman Hanson. Assemblyman O'Neill.
No.
Thank you, Assemblyman O'Neill. Is there further discussion on the motion? All right, I don't see further discussion. Members, if you could please unmute yourself. The motion is to amend and do pass Assembly Bill 424. All those in favor, please signify by saying aye.
Aye.
Aye. And if anyone is, hold on one second. Assemblywoman Summers Armstrong, did you have something?
I was saying aye. I could not get myself muted.
That's okay. We'll note that for the record. So we have taken the ayes. Anyone opposed, please say nay.
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 Okay.
Nay.
Could I have a show of hands for the nays, just so I can make sure I got it for the record? So we have nays from Assemblyman O'Neill, Assemblywoman Krasner, and Assemblyman Wheeler. I think that's it. So that would be 3 nays if I'm counting right. And so we do have enough votes to pass the bill. The motion carries. And Assemblywoman Wynn, another floor statement for you.
Feel free to share the wealth.
Well, I will, Vice Chair Wynn, I'll leave it up to you. If you want to designate anybody else to take your floor statements on the floor, I'll allow you to make that assignment. So that takes us to, I think, the last bill that we haven't yet covered on the agenda, which is Assembly Bill 425. Ms. Thornton.
Thank you, Chair. Assembly Bill 425 is sponsored by this committee and heard in committee on April 5th. This bill establishes provisions relating to the criminal forfeiture of property used in or derived from unlawful acts relating to the possession, distribution, or use of controlled substances. There are 2 proposed amendments to this measure. The first one by Lisa Rasmussen, Law Offices of Christina Wildeveld and Associates. It does the following. It first clarifies the criminal forfeiture process under this chapter applies to any seizure that includes U.S. currency of $5,000 or less. And secondly, it revises the proposed amendment from Kendra Birchie and John Pirro by striking the language concerning the value that is subject to forfeiture. The second amendment is proposed by Kendra Birchie, Public Defender, Washoe County, and also John Pirro, Chief Deputy Public Defender, Clark County Public Defender's Office. The amendment revises in Section 8 certain provisions that the Criminal Forfeiture Process Act govern by adding transportation, sale, or trafficking of a controlled substance and deleting possession, distribution, or use of a controlled substance. B is withdrawn, and the amendment before it takes precedence. Next, it revises Section 10 by making conforming changes and by providing that contraband, real property, or personal property used in or derived from possession or purchasing illegal substances are not subject to forfeiture. Next, it revises the standard of proof in Section 6 in subsection 5D from a preponderance of the to clear and convincing. It makes conforming changes in Section 19, 21, and 35. It authorizes the court in Section 12, subsection 2, to issue a preliminary order for the seizure of property if the state proves by clear and convincing evidence that the property is subject to forfeiture. It revises the standard proof in Section 22, 27, and 28. And lastly, it provides in Section 28, subsection 7, that the prosecuting attorney may not use the information in the petition filed by the innocent owner in the criminal proceeding against the defendant. Thank you, Chair.
Thank you, Ms. Thornton. I appreciate that. Committee members, just to anticipation of potential questions, I wanted to say a couple of things. One of the concerns that was raised at the hearing was, I believe, how to value property and how you would determine whether something would be subject to this procedure or the other asset forfeiture procedure. So I think one of the amendments simply says if it deals with currency and it's $5,000 or less, then you get this process. If it's not currency, if it's some other piece of property, then it would go through the normal process. So you wouldn't have those concerns about how and who is going to put a value on the item that is seek to be forfeited. And I do believe that with the absence of the public defenders, who I can't remember if they were in support, opposition, or neutral, but I believe they are satisfied with the amendment. I do believe that law enforcement and prosecutors still maintain their opposition even with the amendment. Obviously, if the bill goes forward, they'll continue to work on that over in the Senate, but I believe that to be the case and wanted to just put that out there in case it made a difference to anybody. Any questions on Assembly Bill 425 as detailed on the work session document? I don't see questions, so at this time I'll take a motion to amend and do pass.
I would make a motion to amend and do pass.
Second.
All right, we had that worked really well. So Vice Chair Wynn made the motion. Assemblyman Miller got his audio working quickly and made the second. Is there discussion on the motion? I don't see any hands up for discussion. Members, if you could please unmute yourselves. The motion is to amend and do pass Assembly Bill 425. All those in favor, please signify by saying aye.
Aye.
Aye. Anyone opposed, please say nay.
Nay.
Could I have a show of hands on the nays, please? It's like Assemblyman O'Neill is a nay. I believe that's it. Let me know if there was any other nays. Don't see any other nays, so the motion does carry. I feel like I shouldn't take the floor statement on that one. Does anybody else? Would anybody else like the floor statement on Assembly Bill 425? Assemblywoman Bilbray Axelrod has her hand up, so I'm going to give her the floor statement. Committee, that we got through 18 bills in an hour and 13 minutes, so thank all of you for doing that. What we are going to do at the moment is, well, in just a second, let me do this first, just to make sure we get this under our belt. We do have a time for public comment on the agenda, and let's go ahead and take that now. So as a reminder, public comment will be 30 minutes at the end of each meeting, or in this case, at some point in the meeting. Public commenters will have 2 minutes to provide public comment. Public comment is a time to bring up matters of a general nature within the jurisdiction of the Assembly Judiciary Committee. BPS, could we go to the phone lines to see if there's any public comment this morning?
Good morning. Thank you, Chair. For callers wishing to provide public comment, please press *9 now to take your place in the queue. We will begin with the caller with the last 3 digits of 037. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Tanya Brown, TONJABROWN, Advocates for the Inmates and the Innocent. Good morning, Chairman Yeager and members of the Judiciary. On behalf of the Advocates for the Inmates and the Innocent, we would like to say we are extremely thankful and appreciative to all the sponsors and members of Judiciary for bringing these bills forward. You have put in a tremendous amount of time and energy into these bills, and for that we are forever grateful. Thank you. Have a wonderful day and a lovely weekend. Bye-bye.
Thank you for your public comment, Ms. Brown. We hope you have a lovely weekend as well. VPS, are there additional callers on the public comment line?
Yes, Chair. Next caller with the last 3 digits of 556. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Anne Marie Grant, ANNEMARIEGRANT, sister of Thomas Purdy, who was killed by Reno Police and Washoe County Sheriff's Office during a mental health crisis. Some of the things my brother told the sheriffs when they had him hogtied during the medical evaluation that he got by NavCare, who has had umpteen amounts of lawsuits against them, and the jail decided to renew their contract after 14 plus deaths and lawsuits. He told them he couldn't breathe. She asked him why he couldn't breathe. I mean, after being tied up like an animal for 40 minutes, nobody probably could breathe. But my brother actually had a collapsed lung. Divulged that to him. I had major lung surgery, ma'am. They tried to tell my family my brother was out of control and that he died from excited delirium. Well, as you know, I'm obviously following the trial of George Floyd's murderer, Derek Chauvin, and there are 10 symptoms of excited delirium, and to fit the criteria, you have to have at least 6 of them. My brother exhibited 1. He was sweating profusely, but he had a sweatshirt on and had been hogtied for 40 minutes. People think about officer-involved deaths and they think just shooting, but there have been over 6,000 people who have died because of police vehicle pursuit deaths, and those just aren't the people they're chasing. On February 22nd, 2020, 30-year-old Jacob Randall Edwards died in a vehicle accident because Sparks police were chasing another individual. Jacob was born in Gainesville, Florida, to Mark and Judy Edwards. Jacob was a very gifted pianist who had graduated from Douglas Anderson School of Arts. Music was Jacob's life, and many memories were made as a pianist. I'd also quickly like to mention David Lee Kuhn, who was killed 7 years ago today during a traffic chase by Eureka County Sheriff's Office. I recently was in contact with one of his family members, and to this day they have received 0 documents from Eureka County Sheriff's Department. Please support bills that promote transparency and accountability from law enforcement. There's many families counting on you. Thank you.
Thank you for your public comment, Ms. Grant. BPS, do we have additional callers on the public comment line?
For callers wishing to provide public comment, please press *9 now to take your place in the queue. And Chair, the public line is open and working. However, there are no further callers at this time.
Thank you so much. BPS, I will close public comment. Committee members, again, I don't know if there were 18 or 19 bills. I've lost count, but thank you for helping us get through that. At this time, I'm going to be recessing to the call of the chair, and I would just ask members not to leave the building or go too far, because there's always a possibility that we might be coming back to consider other bills, either this morning or this afternoon. I just don't know if that's going to be the case yet. So if you could please stay close, and please either you or have your attachés monitor your emails, because if we do end up coming back for additional bills today, I will let you know by email, text message, and other means. So thank you, committee, for your hard work so far. And at this time, we will stand in recess to the call of the chair.